The United Kingdom Home Office has revised its policy guidance for the applicants applying for British citizenship. Before we continue, please support us by liking, sharing and commenting on our videos. So today we are going to talk about new rules for British citizenship, updated policy guidance. Although the changes are slight modifications, such as swapping interim entrants with immigration bail, and the interpretation that spouses and civil partners of British citizens in the military must be deemed under the principles for spouses and civil partners of Crown servants, it is essential to be mindful of the numerous obligations that must be persuaded before making an application for British citizenship in the United Kingdom. Our partner solicitors specialize in British citizenship applications and will be pleased to be able to help with any new visa applications. Please comment below so our team can organize a preliminary session to examine your British citizenship case. Naturalisation as a British citizen, what is it? To naturalise as a British citizen implies that you attain a British passport and as a result free from immigration limitations in the United Kingdom, which almost all migrants desire. Before making an application for British citizenship, applicants should possess permanent residence or indefinite leave to remain in the United Kingdom. The path to naturalisation might differ, relying on the applicant's immigration history and whether all of the obligations may well be met. For instance, if an applicant makes an application for a spouse visa and fulfills all of the obligations for both the primary and the extension application, they can then apply for ILR and then British nationality next year, which means it has only taken 6 years to attain a British nationality. On the other hand, one of the obligations for the spouse visa could not be fulfilled, but the Secretary of State still practiced discretion and permitted the visa, but put them on the 10-year-long residence route, then it may take up to 11 years to get British nationality. The obligations that an applicant should fulfill differ marginally based on whether they are married or in a civil partnership with a British national. In cases where the applicant is married, or in a civil partnership with a British national, they must fulfill the obligations of Section 6(2) of the British Nationality Act 1981. Other applicants are obliged to fulfill the obligations of Section 6(1) of the British Nationality Act 1981. Kids under the age of 18 may not be naturalised as a British nationals. Where a kid is involved on an application, the Home Office must reflect whether that kid is currently a British national, or if they can be listed as a British national either because they have in right or at the will of the Home Secretary. Naturalisation as a British citizen, what are the requirements? For applicants who are married or in a civil partnership with a British national, they must prove that the following obligations are fulfilled for their British nationality application. Applicant is required to be of good character. Applicant is required to be married to, or is in a civil partnership with a British citizen. Applicant is required to meet the English language obligations and demonstrate adequate awareness of life in the UK. Applicant is required to be at least 18 years of age. Applicant is required to fulfill the residency obligations, including not having too many absences from the United Kingdom during the qualifying phase, and applicant should be of full capability. The obligations for applicants who are not married or in a civil partnership with a British national are very much same, but with the exception of the marriage obligation. They should also demonstrate that they plan to make the United Kingdom their primary home. We hope you liked the video. Please don't forget to hit the like button and share this video on your Facebook, WhatsApp and Twitter. Thanks for watching.